Angela Chiang from the International Affairs Department at the Auto Care Association. Before we begin, I would like to invite any of our attendees to submit questions at any time during our presentation. You should see a question pane on the GoToWebinar control panel. We will collect these and address them during the Q&A session at the end of today's presentation. Our panelists today have extensive background on international trade-related matters in each of the 3 NAFTA countries. Our first panelist is Yohai Baisburd, a partner at Dentons International Trade practice in Washington, D.C. He leads the firm's U.S. trade team in matters around the globe. His diverse international trade and customs practice focuses on counseling U.S. and foreign companies, U.S. trade associations, and governments in a variety of international trade matters globally. He is recognized as a leading international trade and customs practitioner. Next, we have Paul Lalonde, a partner at Dentons in Toronto. He is widely recognized in Canada as a leading practitioner in international trade, government contracting, and anti-corruption law. Over the past 25 years, he has been involved in some of the most high-profile trade disputes involving, including softwood lumber, steel, and agricultural products. And sharing the Mexican perspective today is Gregorio Canales, a founding partner of the Monterrey office. He has extensive experience in corporate law in the areas of mergers and acquisitions, cross-border financing, complex international transactions, contract manufacturing, energy, and real estate. During his career, he has advised foreign companies that conduct businesses in Mexico, as well as Mexican corporations that conduct businesses abroad. He has been a legal advisor in the areas of energy and international trade, and served as the Mexican advisor at the World Bank and the Minister of Legal Affairs at the Mexican Embassy in the United States. And with that, I'll turn it over to Yohai to begin today's presentation.
Thank you, Angela, and good afternoon or good morning or good evening, depending on where people are. Thank you all for joining us today on what I know is an important topic for the business community in North America and for all of us who are on this call as well. I'd like to just quickly give you an overview of what we plan on doing over the next hour. I will start by giving you some perspective from the United States in terms of where we are in the negotiations and where we're heading, and the impact that last week's announcement by President Trump on the imposition of what are known as 232 or national security tariffs on a wide variety of steel and aluminum products could have on the NAFTA negotiations and on trade within the North American region. Then my colleague Paul Lalonde will discuss the view from Canada on the negotiations, and my colleague Gregorio Canales will handle the view from Mexico. So where are we with respect to the United States? In the United States, we've been focused on what's happened over the last 7 rounds of negotiations. So there's been a lot of progress, and Gregorio will go into more detail about that. But to give some context for the discussion, many of the more easy chapters to negotiate have been concluded, and these are what people refer to as the lowest hanging fruit, because they were generally areas of agreement among the 3 countries where the agreement could be modernized in a way that wasn't contentious. But the most contentious issues are still live and on the negotiating tables. These include the automobile rules of origin, both for autos and for auto parts, and I'll discuss those in more detail in a second. A sunset clause, which was a proposal that the United States brought to the table early on to require either a mandatory renegotiation or some kind of periodic reevaluation of the agreement every 5 years, reflecting the concern amongst the administration that the NAFTA agreement has turned stale, because while it might have reflected the state of the art back in 1994, there hasn't been a robust process to review it periodically to update it. Dispute settlement between the countries, also between investor-state dispute settlement, i.e. the process where if Canadian investors make an investment in the United States and the United States government, whether at the local, state, or federal level, takes actions that the investors believe are inconsistent with its international obligations, they can do investor-state dispute settlement to challenge those actions, and the same applies for U.S. investors in Mexico or Canada. That's been an area of contention. And finally, what's known as Chapter 19, which is a special dispute settlement process for a certain type of anti-dumping or countervailing duties, which was one of the big gets in NAFTA for Canada in particular and Mexico, and has since been contentious on the part of certain people in the United States who view this alternative to the U.S. courts as being problematic, both in terms of sovereignty and also in terms of the decision-making that comes out of those panels. And the final contentious issue is Canada's supply management system with respect to dairy and poultry and eggs, which has been seen as a barrier for some exports from the United States in particular. So on the rules of origin, we all have a common ground of understanding of what we're talking about here. Rules of origin are used to determine which products get preferential treatment under an FTA. It's basically the rules that tell you this product qualifies as made in the US or made in Canada or made in Mexico, and thus gets the benefits of the NAFTA agreement, because the agreement is meant to only benefit products produced in the countries that are subject to the agreement. NAFTA generally uses what's called a tariff shift approach, where basically, let's say you take a steel coil that's classified in one tariff classification, you produce a pipe out of that that's in a separate tariff classification. Is that enough of a shift from one tariff classification to the other under the rules of origin to make it a NAFTA product? If so, that tube gets preferential treatment under the agreement. Certain products, such as the automobiles and auto parts, also require a minimum of regional value content. So it's not enough that you just take a steel coil and make a steel tube out of it, and then from that, some part for an automobile. The total regional value content of that has to be at least 62% under the current agreement. Now that's going to shift if the United States gets what it wants, because the U.S. has tabled a proposal to raise that 62% regional value content up to 85%. So a significant increase of 23 percentage points. And then in addition to having a higher regional value content, they are proposing that at least 50% of that content must come from the United States. And that would be a radical new concept in the NAFTA, because as of right now, there are no minimum content requirements from any particular country. Rather, it's that the total, for those products that require regional value content, that the total regional value content be 62%, and it can come from any of the NAFTA countries. This has been highly controversial within the auto sector, which generally opposes this. Canada and Mexico has also opposed it. It's really, at this point, the U.S. administration who's the principal proponent of this approach. And it's not entirely clear why that is the case, although some speculate that really it's the U.S. steel and aluminum industries who are looking to increase the level of U.S. produced steel and aluminum that makes its way into automobiles. Now, the Canadians have countered, not formally with a counter proposal, but rather with a set of conceptual papers and of a new approach to defining the regional content to include things like research and development and design that aren't currently captured when a product crosses a border. So right now, if GM in Detroit, the process of developing the car, designing the car, all of that intellectual property that goes into the final product and is reflected in the final kind of sales price of the product, none of that gets captured in these regional value content requirements. And so the Canadians have come up with this somewhat novel and creative approach to try to reach a higher level of content by expanding what you consider to be the content in the automobile. And as of right now, this is probably the most contentious issue, and that's changed over time with the negotiations. But last round 6 in Mexico City, the U.S. actually recalled its negotiator on the auto rules of origin back to Washington for last minute guidance from the administration and also from stakeholders because of the concern that the proposal wasn't, let's say, fully vetted amongst the different stakeholders. And so while there had been an expectation that auto rules of origin would be one of the key focuses of round 6, it actually did not happen and has been pushed to what's called the intersessional between round 7 and 8, and round 8, which will be in Washington probably sometime in April. So what are some of the upcoming challenges in the NAFTA renegotiation? First, and Gregorio will touch on this more, you have the upcoming Mexican presidential election. As you might imagine, NAFTA and the U.S. approach to NAFTA is a highly politicized issue in Mexico, perhaps even more so than even it has been in the United States. And so the window for closing a deal closes the closer we get to a Mexican presidential election. We also have our own midterm congressional elections coming at the end of this year. So the closer we get to those elections, the more difficult it becomes to close the deal. And really, closing a deal at all is going to be increasingly problematic for the administration because it will own NAFTA 2.0. So as of right now, NAFTA as a concept has been a really excellent tool for both candidate Trump and also President Trump to express his concerns about the global trading system and his viewpoint towards trade more generally. If there is a NAFTA agreement, and we have an agreement, then that agreement is his, and the value of having a new agreement versus having problems with trade to be able to cite to is unclear calculus, and some argue that the president is better off by having NAFTA to beat up on than trying to come up with a new NAFTA that reflects his priorities, because the main issue he's expressed time and time again are trade deficits, and the nature of the global economy and the economic relationships between Canada, Mexico, and the US are such that whether we have NAFTA or not, or we have, no matter what form NAFTA takes, there will likely be a trade deficit in the United States. And the result of that is problematic when you have a new agreement that you said was meant to deal with trade deficits, and after the agreement goes in place, there remain trade deficits. So the other big news that has impacted the NAFTA negotiations are the announcement last week of these 232 national security tariffs on steel and aluminum. The president announced a tariff of 25% against a wide range of steel products and a tariff of 10% against primary aluminum products. At the same time, and based on some significant last-minute lobbying by the governments, Canada and Mexico were excluded as being a quote-unquote special case. And the language used to explain the exclusion, I think, is really instructive, because it talks about the shared commitment to supporting each other, national security concerns, shared commitment to addressing global excess capacity and for producing steel and aluminum, the proximity between the industrial bases, i.e. we are natural trade partners amongst our region, the robust economic integration between our countries. So well-cited statistic that the average automobile crosses the border about 7 times when you think about the supply chain and the various parts and components that go back and forth between the 3 countries as an automobile is being assembled. And for all of these reasons, there's a close relation of economic welfare between the United States and Canada and Mexico, which all suggests that, you know, the importance and underscore the importance of NAFTA, and was the justification for excluding Canada and Mexico from the 232 duties. But at the end, the president pointed out that it's necessary and appropriate means to address the threat to the national security posed by imports of steel from Canada and Mexico is to continue ongoing discussions with these countries, i.e., he's linked the steel and aluminum exclusions to progress in the NAFTA negotiation. This has done a few things. First, it's increased pressure on Canada and Mexico to stay at the table. Not that they were threatening to leave the table, but getting a deal in NAFTA now becomes more important because absent a deal, the Mexican and Canadian steel and aluminum industries would be subject to 25% and 10% duties. It's also increased the attention of the whole NAFTA negotiation and these 232 duties from the U.S. Congress. Republican leaders in particular have expressed concerns about the 232 duties. While they generally say that China has been an issue and should be the focus of concern, they've pretty uniformly come out in opposition to imposing these 232 duties on our allies and economic partners like Canada, Mexico, and the Europeans, among other countries. And Congress is now actively considering legislation to eliminate the 232 duties. And this has happened in the past. One of the last times President tried to put in place 232 duties was in 1980, and Congress passed a veto-proof bill to revoke those duties at that time. So the main outcome of right now in the short term about the announcement of the 232 duties on steel and aluminum is that it's kind of reinforced and emboldened the business community and Congress to take both a more active role in the NAFTA negotiations to try to bring them to a successful conclusion, and also to relook at congressional authority in the area of trade to advance the priorities that the Republican congressional leadership has had traditionally with respect to facilitating trade and market access, both for U.S. exports, but also for U.S. businesses and consumers that are dependent on certain imports. And with that, I will pass it off to my colleague, Paul Lalonde, so he can give the view from Canada.
Well, hello, everyone. I'm just waiting to be given control of the slides here, but while I do that, I do want to thank the Auto Care Association, Angela Chiang in particular, for herding this particular group of cats to be before you again today for this presentation. We're delighted to have the opportunity to give us your thoughts, to give you our thoughts on NAFTA and to take questions from you on how the negotiations are going and how they might impact your industry. So I think at this point, I should be in control. And I am. Okay. So I'm going to give you the view from Canada of how the negotiations are going and where we expect them to go in the coming months. But to understand the Canadian perspective, a bit of context is necessary. So a reminder that we've had free trade with the U.S. We've had generally zero tariffs between our two countries, subject to certain exceptions, since 1989, which is quite a long time now. We're the biggest export customer for U.S. goods still to this day. You ship outside of your country goods to Canada more than to any other country in the world. The other thing to understand is that the two-way trade between the U.S. and Canada, if you look at the value of that two-way trade, it's about the same amount as 40% of Canada's GDP. So when you compare the size of the trade relationship to the weight of our economy overall, it's very big indeed. And so trade with the U.S. is existential for us in terms of our economic well-being. So again, we're a big customer. 18% of all your exports come to the U.S. And all this means that it's the highest possible priority for Canada to get NAFTA right. Politically, there is no bigger issue for our Prime Minister's office. And in terms of his chances of re-election in 2019, and so on. This is a file that absolutely has to get, that he absolutely has to get right, and that's the subject of daily front page news. So we have to get NAFTA right. At the same time, Canada is doing everything it can to expand overseas trade, to give itself as many options as possible in the event that things don't go well at the NAFTA negotiating table. And the other thing that we're trying to do, or at least our government is trying to do in terms of the NAFTA renegotiations, is to weave into the NAFTA some of the progressive trade agenda that we've been able to advance in other trade agreements, including the TPP and others that we've concluded in the last several years. In terms of specific negotiating targets that Canada's tabled, you're looking at integrated environmental protections. This is what Canada has announced as its negotiating priorities. Strengthened labor standards, freer markets for government procurement. On that particular front, it's not going particularly well. The U.S. is rather going in the other direction. Easing cross-border movement for professionals. Under NAFTA, there's a number of professions where it's possible to get NAFTA visas that make it much easier for professionals in these categories to move across the border and to go work in the other countries. We're looking to expand that list. We're looking at bringing into the NAFTA concepts of gender equality and the recognition for indigenous rights. Again, on these two things, we're not getting a lot of traction with U.S. negotiators, at least so far. Yohai mentioned it. Canada has made it very clear that it intends to preserve its agricultural supply management system for dairy, poultry, and eggs. And again, that is a large target for the U.S. negotiators. And finally, on dispute resolution, there's been a number of different things. Our initial salvo was that we wanted to preserve all of the dispute settlement mechanisms that are in the NAFTA at this time. Right now, I think my own view is that Canada would be prepared to sacrifice the other dispute resolution mechanisms if it can hang on to Chapter 19, which is the dispute resolution dealing with anti-dumping and countervailing duty actions taken by the U.S. and Mexico. The tone of the negotiations, well, they've been up and down. Some of the rounds seem to have gone a little bit better, and at the conclusion of them, the representatives from the U.S., Canada, and Mexico have had differing levels of irritation with one another that's come out. I would say that the last round was somewhere in the middle, in that there seemed to be some reason for optimism. That I found that the representatives from U.S., Canada, and Mexico seem to be working very hard to find positive things to say. And even though really on the fundamental issues, there was little progress on the important gap still to be bridged between the negotiators. Canada still considers the hard demands of the U.S. with respect to supply management, with respect to the automotive rules of origin, with respect to the dispute resolution mechanisms, and with respect to this idea of a 5-year sunset clause being baked into the agreement to be unacceptable. Canada has made it repeatedly clear that none of those things it can live with, really in any way. Perhaps some measure of flexibility on dispute resolution now that we haven't really seen before, but on the others, really Canada hasn't signaled that it's heard anything yet that is close to acceptable. The negotiators did report some completion on a number of chapters. I would say, secondary window dressing type stuff. There's been progress, and They've been able to close some of the chapters, things like competition policy and sanitary and phytosanitary measures, things of that nature. They've been able to close the books on some of the chapters, which is great, and indicative of progress, but still major gaps on very key U.S. demands. The other thing that's kind of complicated the negotiating table, Yohai spoke very well about the steel tariff, the steel and aluminum tariff situation, the exemption that's been provided for Canada, and what that's done to the negotiations of NAFTA and the pressure that it exerts now on Canada and Mexico to focus the mind and sharpen their pencils on the NAFTA front. The other thing that's been tossed into the mix since we last spoke to the Auto Care Association about NAFTA is the filing by Canada of what I've glibly called the WTO mega case. The Canada has filed a complaint with the dispute settlement body of the WTO that addresses about something like 200 specific complaints that it has about the U.S. anti-dumping and countervailing duty system. Interestingly, a lot of those complaints don't even involve cases where there were imports from Canada at play, but nonetheless, Canada has identified approaches taken by the Department of Commerce and the ITC in a number of these cases as being objectionable under WTO, being inconsistent with the U.S. obligations under the WTO, and it has initiated this dispute settlement mechanism to attempt to bring the U.S. to order, to get a declaration from the WTO that the U.S. system in all these respects is inconsistent, and to, through that system, do what it can to compel the U.S. to bring its system into compliance. The U.S. reacted with some anger at this case and frankly some bewilderment as to why Canada would bring a case that would change things about the U.S. anti-dumping system that don't even apply to imports from Canada, and wondered why Canada was going to such lengths to try to help other countries exporting to the U.S. And so strong reaction from the U.S., strong unhappy reaction from the U.S. But Canada is pushing ahead with the case, maintains that it has a legitimate beef with the way the U.S. administers its trade remedy system, and I think is trying to use this as a form of leverage in the context of the negotiations vis-a-vis the U.S., so that if there was a comprehensive settlement of NAFTA, if we arrive at a NAFTA 2.0, that resolving this case or setting aside this case might be part of that mix. Yohai spoke about the U.S. aluminum and steel safeguards tariffs. The only thing I'm going to add on that is that the U.S. has made it pretty clear that it considers a conclusion of NAFTA, of a new NAFTA, a condition of the maintaining of the Canada and Mexico exemption. Both Canada and Mexico have made it very clear that they consider that there is no link between the tariffs and NAFTA, that they are entirely separate issues, and that they don't accept the idea of any horse trading between those steel safeguard tariffs, steel and aluminum safeguard tariffs, and anything that's going to happen under NAFTA. At least that is the official position of Canada. Whether at the negotiating table things will play out differently, I think that's fair speculation. So one of the questions that we receive constantly from clients and contacts and collaborators, colleagues is, well, what's going to happen? What are the chances of NAFTA being successfully renegotiated? What's going to happen if Mr. Trump does indeed pull the termination trigger, what will be Congress's reaction, et cetera, et cetera. There's a lot of different scenarios that may play out in the coming months. And what we've tried to do is sort of organize these scenarios, set out the likely scenarios that we can see unfolding over the coming months, and then assessing the likelihood of that scenario materializing. And that's what we've done with this next slide. So, I mean, if I take you through it quickly, if you look at the first row, status quo, the NAFTA continues the way it is now. Then the next column is likelihood, and you'll see there we've assigned a 2 to 3 score for that likelihood. And what does that mean is that on a scale, on a 5-point scale, with 5 being highly likely or the highest likelihood and 1 being the least likelihood, this is our assessment of the range of expert opinion on whether this scenario is going to materialize or not. And then the last column gives you the likely duty impact. So what is this going to do to NAFTA treatment of merchandise trade between the 3 countries? So currently, status quo, the duty treatment for merchandise between the 3 countries is free. So maintaining the status quo, of course, leads you to a duty-free impact, and that's what we've got there. So if you go down the various scenarios, that gives you our assessment of expert opinion or expert, I don't even want to say consensus, but the range of expert opinion out there for the different scenarios that we see materializing. The next one is NAFTA 2.0. So a successful renegotiation of the NAFTA. And you'll see that that has a relatively high score in our view of 3 to 4. But the duty impact is unknown. There may be some changes to the duty treatment for merchandise. That will be a question to be negotiated. But likely, we're not going to see a lot of change in the duty treatment of merchandise between the current NAFTA and a NAFTA 2.0. So unknown, but likely free. So that gives you an explanation of how this table works and how the various scenarios we believe are conceivable are assessed and explained in the table. I won't take you through all of them because we only have a short time together, but I think it's an interesting visual representation of the various scenarios and what is likely to happen as they play out. So the other thing I wanted to talk about a little bit was what we've been doing for clients, and basically it breaks down into a few important categories. The first one being helping clients do NAFTA risk and sensitivity analysis, so understanding what the impact of changes to NAFTA or a termination of NAFTA might have on clients. The other thing we help clients with is to do a review of their supply chain and to ensure that their contractual understandings with their supply chain and with their distribution chains properly protect them from the risks that are presented by a possible termination of NAFTA. And then for specific clients, the changes in rules of origin may have a very significant impact, so we help them review what that impact might be. And then this is often a good opportunity for clients to have a good kick of the tires, if I can put it that way, on their trade compliance policies and practices, and we help them through that as well in the context of the possibility of a termination of NAFTA. So that concludes my remarks. I'm going to pass it over to Gregorio for his, and then hopefully we'll have a bit of time for questions. Thanks.
Thanks, Paul. And I also want to thank the AutoCare Association, and particularly Angela, for having us again in this webinar. After my two colleagues, I want to focus on struggling here. Yes, okay. So as mentioned before, Mexico sorry for that. As mentioned before, Mexico has an upcoming presidential election on July 1st. Officially, the campaigns start at the end of March, and obviously, NAFTA being such an important component of our economy, it's a major issue in the election, and the outcome of the election is seen as a referendum on NAFTA. It is Mexico's preference to remain a trilateral agreement between Canada, United States, and Mexico. I think the agreement has worked out well for Mexico, and we, as a country, like to remain in the NAFTA. In connection with the recently imposed tariffs on steel and aluminum, Mexico, even though that we have been excluded from that tariffs, we don't see this as a favorable development because it might signal the beginning of a trade war, or at least a trade and noise over the trade negotiations that are currently being held. As you all know, round 7 of NAFTA was concluded in Mexico City just a week and a half ago, and the 8th round of NAFTA is expected to take place in Washington in April. However, and I think this is an important point, we should point out that the Trans-Pacific Trade, which is an agreement between 11 countries, has been executed successfully by Canada and Mexico, and the United States has remained on the side. This is of relatively a very high importance due to the fact that the Trans-Pacific Trade Pact is considered as a more ambitious and complex trade agreement that include many topics that are still unresolved on the NAFTA. So the idea that Canada and United States, Canada and Mexico have agreed on several of these issues, this might seem as a positive development for the NAFTA 2.0 negotiations. Originally, the TPP was considered as a blueprint for the NAFTA negotiations. As mentioned, the negotiations of round 7 have been, progress has been slow. It is very complex, the negotiations. It is a 30 ring circles. So there are 30 tables of negotiations all at the same time, which makes having an agreement difficult. We should keep in mind that even though that negotiators say that they have agreement in certain chapters, the whole agreement is not ready until everything has been agreed upon. So progress has been made. However, there are many other areas in which progress and agreement need to be reached, and everyone is conditioned to the successful negotiation of the entire agreement. The topics that were successfully concluded in round 7 were regulatory best practices, administration, and publication. It has to do with transparency and access to information, as well as phytosanitary and sanitary measures. As has been pointed before, there has still difference on what for this trade group is very important is the rules of origin in the automotive sector. One of the agreements that has been made in this regard is that the parties will continue to have conversations despite of not being in the round. So formal negotiations among the parties between this round of negotiations. However, we should point out that the positions of the three countries still remain distant, but conversations continue to be held. Well, this has already been explained. United States is of the very strong position to have an 85% of NAFTA regional content and 50% of U.S. country-specific content connections with the rules of origins for the automotive sector. The Mexican government, I should say, has expressed his willingness to be flexible on this point. However, Mexican private sector and the Mexican automotive sector in general, which is very strong part of our economy, is objecting to that, and thus has created a tension between the private sector and the Mexican government in this regard, created a domestic conflict. Well, but despite all these difficulties, it is important to point out that Mexico has continued to export to the United States at a very fast pace, and just in 2018, the raise in exports had been for 9.5%. This is despite all the uncertainties that the successful NAFTA negotiation and the presidential election have to do in terms of investment. Also, the auto production in Mexico has been up for 6.2%. So the auto sector in Mexico is strong, it's vibrant, despite all these clouds of the NAFTA negotiations and the presidential elections. And here is basically a summary of what just Paul explained. What are the different scenarios that we in Dentons have identified? And just a quick reminder that Dentons is a global firm with very strong presence in Canada, United States, and Mexico that can assist you with all these trade issues between the three countries. And with this, I terminate my presentation. I want to thank you all.
Thank you so much to our panelists. We're going to begin answering some questions submitted during today's presentation. As a reminder, you can still submit questions through the question pane. Anything we don't get through during the webinar, feel free to email me afterwards. Our first question comes from an attendee. How are the steel tariffs going to impact the final product produced using raw material containing steel? In other words, does the order also include more processed steel products such as coated or tubular steel?
So this is Yohai. I'll answer that initially. So the order on steel and aluminum identifies numerous tariff classifications that are covered by these additional duties, and some of them include tubular products. So if it's a tubular product that falls in one of the classifications that have been identified, then it will be subject to duties. And here it becomes a challenge for downstream companies, metal benders and metal cutters as opposed to integrated mills, because if you import a, let's call it a 20-foot tube and then cut it down to smaller size and bend it to, manufacture a finished good in your plant in the U.S., the imported 20-foot tube, if it falls in one of the classifications, would be subject to the 25% duty, even though you're using it to produce a further processed steel product after importation into the United States. So the president has announced that the duties will become effective March 23rd and has directed the Department of Commerce and also the U.S. Trade Representative to come up with an exclusion process for specific products and also for countries. And so at the country level, there are negotiations now between certain countries and the United States to try to get an exclusion like that was provided to Canada and Mexico. And then the business community will have an opportunity once the exclusion process is announced to apply to get a product exclusion. It'll probably, the primary justification for doing that is if a product is not produced or is not available in the United States, then that's oftentimes the justification and the reason for Commerce to grant an exclusion. But those will have to be done on a case-by-case basis.
Thank you, Yohai. We've received a couple of questions regarding the steel order being imposed on raw materials versus finished goods. So specifically, does the steel aluminum tariff cover imported finished products that contain steel, or is it only raw materials? So in essence, if a manufacturer imports raw steel, raw material to make a finished good in the United States versus importing a finished good that contains steel, do the tariffs apply to one or the other or both?
So the tariffs are tied to specific product classifications, tariff classifications, like I mentioned earlier. So if you're an importer or rely on imported steel in some fashion in your supply chain, then you should go and get the order, or let Angela know and we can get it to you, and see if the products that you're importing or that are imported for you in your supply chain are classified in one of the covered classifications. By and large, these are things like, steel plate and steel coil, steel tubes, things of that nature. So what generally kind of are used as raw materials. The fact, a finished good that's classified as, a finished good, like a brake drum or rotors or lumbar support systems or things like that nature, will not be covered by these tariffs if they're imported in that condition. But, the key is to go find the tariff classifications and see if the goods that you're importing are classified in one of those provisions. So
just Paul Lalonde chiming in here, just to make it clear and perhaps give a simple example. If you're importing a chair that is made, the frame is made of steel, that would be covered by the order if you were just bringing in the steel. But if you're bringing in the chair with its steel frame and upholstery and so on, that chair is not subject to the duties, and the steel portion of the chairs is also not subject to a separate duty for the steel.
Okay, great. Thank you for clarifying that. Next question. Currently, Mexico and Canada are excluded from the steel and aluminum order. What happens if NAFTA negotiations fall apart? Would Canada and Mexico then be subject to the steel and aluminum order in that case?
Well, that's not clear. Paul Lalonde, I'll take a crack at this. The position from Canada is that they're not linked, that a failure at NAFTA doesn't change anything with respect to the reasons that were given for excluding excluding Canada from the tariffs, Canada and Mexico from the tariffs. So we're still an integrated North American economy. We still, have a high degree of integration at a manufacturing level on security, et cetera, et cetera. So the position from Canada is that there should be no link, but it's really up to the administration, and the administration's made it pretty clear there is a link. So what happens if we fail at the NAFTA negotiating table? No one knows for sure, but the betting is that then the Trump administration will withdraw the Mexico and Canada exceptions and see where that plays out, whether it pressures Canada and Mexico to yield at the negotiating table on anything or to come back to the table. All of that will be to be seen. But the betting is that it would lead to a termination of the exemption from the steel and aluminum tariffs.
Okay, thanks, Paul. Our next question, has there been any discussion on the NAFTA renegotiation and how it would impact maquila regulations that predate NAFTA?
So this is Yohai. I think Gregorio might have some views on this too. So the maquiladora program in Mexico is a duty deferral and duty elimination program that encourages the setup and establishment in Mexico of processing and manufacturing plants. If NAFTA falls apart and duties then are placed on Mexican origin goods, that'll have an impact on the investments that are made in Mexico in those maquiladora processing. So the kind of legal regime that governs maquiladoras in Mexico is independent of NAFTA, but one of the benefits of having a maquiladora in Mexico is that products produced there that meet the NAFTA rules of origin currently get duty-free treatment in the US, and that obviously is a large and attractive market. So I would imagine that if the renegotiation, and there's a lot of this about to come, if the renegotiation is unsuccessful, and if the president decides to withdraw from NAFTA, and if that withdrawal becomes effective, then it will have an impact on Mexican maquiladora facilities, even if it doesn't technically change the Mexican law, which is separate from NAFTA.
Yes, this is Gregorio Canales, Mexico. You are absolutely right. The maquiladora industry have been in place much longer than NAFTA, and it is, as you pointed out, a customs program that defers duty. Its main spirit of the maquiladora industry, without getting into all the complexities and technicalities, is that anybody can bring any raw materials, equipment, spare parts into Mexico, included in a manufacturing process to be exported outside of Mexico, so that Mexico would not tax, would allow for the goods, parts to cross the border without any particular tax. Obviously, with NAFTA, all these becomes intertwined, but the maquiladora program should continue to be in existence despite the NAFTA negotiation. It will have an impact, of course, but it is not dependent on NAFTA.
Okay, great. And I think we have time for one more question that's come in. There's been talks about countries retaliating as a result of the steel and aluminum tariffs. How do you see this playing out with companies that currently export to other countries that are not Mexico or Canada?
Yeah, I would expect.
Go ahead. Go ahead.
This is, yeah, I would expect that other countries will look at putting in place duties or taking other forms of action in response to the duties that the U.S. put in place on steel and aluminum, in addition to invoking the WTO dispute settlement process to challenge the actions that the U.S. took. But this is considered the third rail of WTO laws. Invoking national security is a concern that many countries have because almost anything can be defined as national security, and generally countries have exercised restraint to do this because they didn't want to have to justify what it means to take national security action and the impact that can have on others. And it's been the U.S. position in the past, in the case under GATT, so the predecessor to the WTO, that the U.S. took the position on the GATT dispute that the question of national security is one that can't even be decided by the dispute system, that it falls outside of its its authority to look at issues. So if there is a WTO dispute, it's going to be very significant, and it's going to look at this question of what constitutes national security, and that is an area that I think is going to generate a lot of uncertainty and a lot of risk for the international trading system itself.
On that, in terms of the impact of the duties in other countries, totally endorse everything that Yohai just said. I would just add that for Canada and for other countries, the concern now is the diversion of product that would have been destined for the U.S. into Canada and other markets, and having a flood of imports coming in that no longer can find a home in the U.S. and being dumped or otherwise sold at fire sale prices into other markets. And I can tell you that Canada is already set up to monitor imports and to take action to ensure that it doesn't become a dumping ground for diverted exports that would otherwise have been going to customers in the U.S. but can't anymore because of the duties. So the imposition of such high duties on such a high volume, high value set of imports is going to have ripple effects throughout the world and throughout the steel industry on a global level, not just bilaterally between the unhappy countries that are target to the duties and the U.S. It's going to have profound effects all over the world in a lot of different marketplaces. So stay tuned.
Great, thank you so much, Paul. I think we are just a little over our webinar time. I'm just going to wrap it up. Thank you to our presenters and to everyone attending today's webinar. If you have any additional follow-up questions, feel free to email me, angela.chiang@autotear.org. You will receive a follow-up email the next day or two with a link to today's webinar recording. On behalf of the Auto Care Association and our presenters, thank you for joining us today, and have a great rest of your day.
Thank you.
Thank you.
Thank you all.